So hello, everyone, and thank you so much for being here. As Pip mentioned, my name is Kate Bridal. I'm a staff attorney with Mental Health Advocacy Services. And today, my portion of the presentation is going to be specifically about tenancy protections during COVID-19. And then Naomi will talk about fair housing protections that are in place all of the time, not just during this emergency. So a little bit about Mental Health Advocacy Services as an organization. So we are a nonprofit legal aid organization, and our mission is to protect and advance the legal rights of low-income adults and children with mental health disabilities, and empower them to assert those rights in order to maximize autonomy, achieve equity, and secure the resources that they need to thrive. So we were established in 1977 to meet the legal needs of adults and children with mental health disabilities. And we serve LA County. So I know we have people from all over the state of California here today. So we're going to try not to be LA focused and be more focused on statewide things. We do practice areas of law, including, helping people get benefits, fair housing law, as we'll be discussing today. We do some work with removing barriers to employment, of course, homelessness prevention, my project, and also some special education work. So today, my portion of the presentation will cover these topics. So we'll talk about rent increases during COVID, national, state, and some local eviction protections during COVID, what happens to rental debt that's accumulated during COVID-19, and then also some rental assistance programs that are in place right now. So first off, I want to discuss rent increases because this is something that happens a lot. I think people sort of take it for granted that your rent can just be raised however much. But California law actually limits rent increases that are able to be made during COVID-19. So first, there is a penal code section that prohibits price gouging during emergencies, and that includes the raising of rent, which means that rent increases that are more than 10% are not permitted due to the state of emergency. So any rent increase that you hear about that's more than 10% anywhere in the state of California is suspect right now and is likely not allowable. And importantly, this applies even to between tenancies. So it's not just your landlord can't raise your rent when you renew your lease. It's also if you go into a new apartment and they raise the rent more than 10% from what it was for the previous tenant. And this is just a ban that's in place until there's no more state of emergency in the state of California. We also have the Tenant Protection Act, which applies all the time, not just during emergencies. It applies to only certain units, which are apartments that are over 15 years old, single family homes or condos owned by corporations, and duplexes that are not occupied by the owner. And for those properties, the rent cannot increase more than 5% plus a change in the cost of living. We also have some local, I just wanted to go over these local LA protections because there might be similar protections in areas where you all are in other parts of California. So for example, in the unincorporated county of LA, there are no rent increases at all for rent stabilized units, which are units that have 2 or more units in the complex that were built before February 1, 1995. And the city has a similar prohibition. So I suggest that you be sure if there's a rent raise issue to check whether your local eviction protections prohibit rent raises for covered units. I know Oakland, for example, does currently have a prohibition on rent raises for rent stabilized units. They can't increase more than, I believe it's 3%. So it's just important to be checking the local laws, and basically any rent increase should raise a red flag and cause you to look into the circumstances and how much it is and whether it's allowable. So let's get to some protections that are in place due to COVID-19. So this is throughout the entire state of California. Every tenant in the state of California currently has just cause protections until August 1st, 2021 currently. Just cause means there has to be a valid reason to evict you. So normally, this only applies to certain tenancies through AB 1482, which is the Tenant Protection Act. Under normal circumstances, it would only be for certain tenants that would get this protection. But right now, SB 91, which is the statewide COVID bill, extends these protections to everyone. So you can't be evicted for no reason. There has to be either an at fault or no fault just cause reason. And these reasons are enumerated. There are only a certain number of them, and there are only specific reasons that you can be evicted. So at fault evictions are things like that are the tenant's fault. Exactly what it sounds like: breaking the lease, causing property damage, criminal activity in the property, things like that. No fault evictions are things that are not the fault of the tenant, but the landlord needs to evict anyway. So that might be things like the owner needs to move a family member into the unit occupied by the tenant, or the owner is withdrawing their property from the rental market altogether. They're evicting everybody, they're getting out of the game. Those are no fault eviction reasons. And tenants are entitled to relocation assistance equal to 1 month's rent for no fault evictions. And another crucial thing is right now, if you're evicted for something other than non-payment, your landlord can't then pursue you for rental debt that you owe them. So this is basically in response to unscrupulous landlords who were trying to get around the non-payment eviction protections by suddenly saying that a tenant who hadn't paid their rent is causing problems, saying they're a nuisance or something like that. The courts basically have said, okay, fine, if you want to pursue them for this different thing, that means that then you don't get your money back for the back rent. So it's to discourage landlords from making up reasons other than non-payment to evict folks who aren't paying. So as far as protections for folks who aren't paying rent due to COVID-19, people are protected throughout the state by the California Tenant Relief Act, aka SB 91, Senate Bill 91. Tenants have a defense against eviction currently until the end of June. It may get extended again, but for right now, it's June 30th, 2021. If you can't pay your rent due to COVID. And what is due to COVID is fairly broad. It could be that you need extra childcare because your child isn't in school, or you had medical expenses related to COVID, or you're struggling to find a job due to COVID, you're struggling to find a roommate due to COVID to help you pay the rent. There are all sorts of things that can be a COVID-related reason that you can't pay your rent. Unfortunately, the rent doesn't just go away. Tenants do still owe any back rent that they miss, but there are programs in place that hopefully can help with this, which we will get into as well. So what should tenants do to take advantage of these eviction protections? So here's a little bit of a timeline. So what will happen is if you're not paying your rent and it's because of COVID, the landlord will serve you a notice to pay or quit. It has to give you 15 days. If it's anything shorter than 15 days, it's not a valid notice to pay or quit. And it also has to provide you a copy of the declaration of COVID-19 related financial distress for you to sign and fill out and give back to your landlord. In order to be protected, once you have that, you should return the signed declaration within the 15 days. And then once you've returned that, for rent that's owed if you owe rent between March 1st, 2020 and August 31st, 2020, you just have to return one declaration for that whole chunk of time. And then you can't be evicted for your unpaid rent. Again, the rent doesn't go away. The landlord can sue in small claims court after August 1st for that rent, but we'll discuss small claims court more in a little bit as well. For rent due between September and June, so September 2020 and June 2021, you need to return that declaration every time your landlord gives you a notice. So every time you get that notice with the declaration attached, you fill that declaration out, return it within the 15 days. And then an additional requirement for this time period is you need to pay 25% of your total rent by June 30th, and then you can't be evicted for the debt. Now, this does not mean you have to pay 25% of your rent every single month. And some landlords are trying to tell tenants that that is what it means. It is not. It's 25% for the total period, and you can pay it in one lump sum on June 30th if that's what works for you, and then you'll be protected. And then again, what happens to the remaining 75% that you didn't pay? Landlords can pursue that in small claims court. on or after August 1st, 2021. And the other thing that I want to mention is all non-payment eviction actions. So if you've already had an eviction filed against you between March 4th and the end of this, and actually it's until the end of July. So between March 4th, 2020 and July 31st, 2021, those eviction actions are all masked, which means that it doesn't show up on your record. The rental debt that you owe still will show up on your record and credit report, but the fact that you had an eviction filed against you will not. And that doesn't matter. Usually these actions are only masked if the landlord loses. Right now, they are masked no matter who wins. So even if your landlord successfully evicts you, if it's between March 4th, 2020 and July 31st, 2021, it shouldn't show up on your record that you got an eviction against you. So what happens if you miss that deadline? You don't return it within the 15 days. Well, that's okay. If you've missed the 15-day deadline, you can still file it within the time you have to file an answer in court. And so once your landlord files the action, you missed the deadline, your landlord files an eviction in court, the court will issue you a summons, and you have 5 days from that summons to file an answer. And if you don't file an answer in that 5 days, you can get a default judgment against you, which means your landlord automatically wins. So it's very important to file your answer. And then you can still also file your declaration within that time period. And then the court will hold a hearing to determine if you missed that deadline for a good reason. Even if you don't get it within that 5 days, you are able to request a reasonable accommodation at any point in the eviction process, including during the eviction or even after an eviction trial has ended. So if you are someone with disabilities and that disability caused you to miss the deadlines, say you were sick, you were in the hospital, that's a really obvious one, right? And you couldn't get it in time. That would be a reason to ask for a reasonable accommodation to still be able to submit that. Or it could be that you have severe anxiety, or you have a disability that makes it very difficult to meet deadlines or remember deadlines, things like that. If your disability is related to why you missed the deadline, then file a reasonable accommodation request and ask to still be able to file that, even if you missed both the deadlines. So I've mentioned that landlords can recover rental debt in small claims court. So I want to talk a little bit about how small claims court works. So first off, there will be none of this before August 1st, 2021, or at least there's not supposed to be. Landlords, these actions can't move forward until that time. Once they are initiated, then court dates are scheduled within 3 months of filing. And then the hearings only last 10 to 20 minutes, and then the decisions arrive within 2 weeks of the hearing. So it's a pretty quick process. There are no lawyers in small claims court, which can be really scary, understandably so. So tenants don't get a lawyer. Landlords also don't get a lawyer in court. But again, the hearings are only 10 to 20 minutes. So, and there are a lot of places that will help you prepare. Even though a lawyer can't represent you in small claims court, I definitely recommend, if you're facing one of these actions, to contact a legal aid organization that's near you, and they can possibly help you prepare for this small claims action. You can also contact the courts themselves, sometimes have self-help clinics that will help people with this kind of thing. So definitely don't feel like you have to go into it alone and with no one to help you prepare for it. Judges might reduce tenants' debt if the landlord didn't accept rental assistance. So we're going to talk about rental assistance programs in a minute. If you tried to get rental assistance and your landlord refused to participate, then the judge can dock your landlord for the amount that they refuse to accept from rental assistance and say you don't owe that to them because they failed to mitigate their loss. And again, these proceedings, these small claims actions, will all be masked, which means, again, the debt will still show up on your credit report and your record, but the actions in small claims court will be masked, which means no one will be able to see that your landlord took you to court over this debt. And some landlords are trying to threaten this, small claims action. This is going to show up on your record to get tenants to sign deals that aren't good for them. Just don't be afraid of that. It's not true. No one will be able to see that your landlord took you to court over this. And finally, definitely ask for an interpreter if you need one. You are entitled to one. So if you need an interpreter, don't be afraid to ask the court to give you one. Okay, I want to talk a little bit. Oh, Naomi, was something.
Oh, yeah, no, we had a question in the
Sure.
chat about small claims court and whether the hearing can be conducted virtually. I know that's been happening during COVID-19. It's an option to do the hearing virtually. I'm not sure how long that's gonna continue. Whether, you know, I think it kind of depends on what happens with the state of emergency and what happens with COVID-19 in California. Kate, I don't know if you've had more of a sense.
I No, I don't have much of a sense. Because they're not happening yet, I haven't really heard much about it. So, but I know that you in other branches of MHAS do small claims stuff. So I think you're actually more in a position to know than I am.
Yeah, we've had clients go in person, but have had the option to do it virtually.
Okay.
And there's always a fee waiver option for folks that can't afford the filing fees in court, which can be hundreds of dollars. So if you are low income, and so if you're on Medi-Cal or you get like SSI, food stamps, any type of benefit qualifies you to file, and defend cases for free in court. And then even if you're not on a benefit but you're low income, you can explain that and get a fee waiver granted automatically. If it's not automatic, you can have a hearing before a judge to explain why you need the fee waiver. The other thing I'll say about small claims court is I know during COVID, for folks that have been going in person. And again, these aren't rental debt cases yet, right? Because
Right.
those rental debt cases shouldn't be filed until it's July 1st, right?
August 1st.
August 1st. But we do have folks that have been going into small claims court on other matters. And they have been attempting to limit the number of people that can go in on a case in person now, to sort of limit the spread of COVID-19. But if somebody with a disability needs to go into court and they need a support person there who may not be, somebody to help them, with whatever, whatever they need, whatever type of support, physical, emotional, whatever they need, if it's related to their disability, they can ask for an accommodation to have a support person or two there with them, even if there are limitations on, say, only parties can show up in court. So that's an important thing to recognize.
Yeah, that's a great point. Thank you, Naomi. Okay, so just a little bit about the CDC order. This applies nationally, and you probably might have all heard about it. It protects against non-payment evictions, even if your non-payment is not related to COVID. So that's the big reason that I want to bring this up, because all the other protections I've talked about are specific to if you can't pay your rent due to COVID-19. If you can't pay your rent, but you can't really make a link between that and COVID, you might be protected by the CDC order. It has similar requirements. You have to submit a declaration, but there's no requirement of paying 25% of rent. And there's no time limit for when you can submit that declaration. You don't have to do it within 15 days of getting a notice. We're still figuring this out. It might protect you against being evicted for a no fault reason. Some courts are saying no, it's something that's sort of being debated, but it's worth a try if you're getting a no fault eviction. And it has also been extended to the end of June, which I put an exclamation point for when this first happened because it was very unsure for a second. And now I feel like the exclamation point is less relevant, but it's still exciting. It's great that this protection is also in place for so long. And then this is just an example. So I have the LA City, an example of our local eviction protections. Obviously, check the eviction protections that might be in place for your city in particular. If you don't have any, it might be, you'd be protected by the state. Or it might be your county as well. So counties, LA County, for example, has a different set of eviction protections. But for example, the city of LA, they were smart. They tied their evictions to the end of the local emergency. So they never had to renew it or extend it, which protected it from being interfered with by the state law. So the state law came in and said, you can't renew or extend anything that protects against non-payment evictions. But the LA City didn't need to renew or extend. So their non-payment protections are still in place. They also have a prohibition on no fault evictions. So some of your jurisdictions might have this as well. You're not allowed to evict for any of those no fault reasons, like owner moving in or moving a family member in or withdrawing from the rental market. And they also have a protection for evictions for unauthorized pets, occupants, or for nuisance if it's related to COVID-19. So if, for example, your child is normally at school for most of the day and now they've been home more than usual, and your child maybe, runs around and is a kid and makes more noise than they're normally making during the day, and someone says that it's a nuisance, that could be family status discrimination, which Naomi will talk about a little more, but it's also protected under this ordinance because that nuisance is related to COVID-19, right? Your child would normally be in school at those hours and would not be, making noise at home. Or for example, your mom needs help. Maybe she got evicted and has nowhere to go, and she's concerned about COVID, so she doesn't want to move somewhere else, so she lives with you. You can't be evicted for having your mom there because it's due to COVID. If your mom has a dog and she brings that dog with her, again, you can't be evicted because that unauthorized pet is there due to COVID-19. LA counties is very similar. Just wanted to illustrate that cities and counties might have different protections, so definitely check what your local protections are. And then there is rental assistance for the state of California. Certain cities also have their own rental assistance programs. Their cities, I believe, of 200,000 or more had the option to do their own rental assistance programs or go with the state's program, and counties as well. And so LA County, for example, is just going with the state of California program. The city of LA is doing its own. So again, if you live somewhere like San Francisco, I am not sure, they might be having their own rental assistance program apart from the state one. But the great thing is you can go to this website, try and get rental assistance from the state of California, and they will tell you if you live in a city that is providing its own program and you need to go there. So it doesn't hurt to try, basically. Immigration status has nothing to do with this. You can get this help regardless of your immigration status. From what I've been told, there's not even a question about it on the application. And your rental assistance can be used for back rent, so rental debt from April 2020 to March 31st of 2021. The landlord or tenant can apply first, and then the state will pay 80% of the debt directly to the landlord, as long as the landlord agrees to forgive the remaining 20%, which means that your back rent would be wiped out. Of course, this requires landlord participation. Not all landlords are going to choose to participate. If your landlord refuses to participate in the program, then you can still get 25% of your rent directly to you, so that you can pay the 25% for that time period and avoid being evicted. You can also get help for up to 12 months of your future rent payments, 25% of your future rent payments. And you can use this help for utilities. So if you have a backed up utility bill because you've been prioritizing your rent, but you haven't been paying your electric bill and you've got a big electric bill debt, you can use this money for that. And also other household expenses. I'm not sure exactly how they're defining those expenses or what they allow for, but basically what I say is it's worth trying. If you have something you need help with, it's worth trying to apply for this, because the worst thing that can happen is they say no. So that's my input on rental assistance. And then, like I said, the city of LA, if you happen to be in LA City, the city does have its own rental assistance program. This one you only have until April 30th to apply. So if you are in the city of LA, please, please, please apply for this program as soon as you can. It has a slightly lower requirement. You have to be 50% of area mean income or below rather than the state program, which is 80, but it's still worth it to give it a try. And that is it for me.
Great.
Do we have questions? Do we want to do questions?
There is actually a question from one of the attendees who is asking, who would we go to let them know that being evicted in order to move in their family? And I'm sorry, I'm not clear on that. Let me see if I can unmute her so that she can No, I think she's,
I think that the question is asking if a landlord is evicting me now during COVID to move in their family. You just mentioned that was not,
oh,
that's not allowed right now. So who would they go to if that's happening to them currently? And then Jocelyn, if that's not right, just go ahead and chat and clarify the question for us. But I think that's what it was asking.
Yeah, so it is allowable in some places. So it's going to, so throughout the state of California, that is currently allowable, but there might be a local protection. Oh, Sacramento. I don't off the top of my head know what Sacramento's protections are, but I can try and look them up actually while Naomi is doing her presentation. So I'll try and look at that for you. I can't guarantee I'll be able to find it, but basically your local legal aid organizations, I'm not sure what orgs operate in Sacramento. I'm sure they have plenty of.
There's legal aid up there, or obviously a private attorney, for folks that are over income for legal aid. If you get an eviction notice, it's absolutely a good idea to run it by an attorney.
Yeah, always.
Because they'll be able to tell you, all the ways in which, perhaps the eviction notice won't actually support an unlawful detainer case. Maybe it will, right? But they'll be able to help you analyze that and figure out what are the protections for you.
Yeah, so if you can afford a private attorney, there are, most counties have like bar referral programs. You can go on a website and you put in what you need help with. Some of them cost a little bit of money. I don't think anything costs too much, but, and then they'll give you an attorney that can help you with that issue, a private attorney. Otherwise, if you can't afford a private attorney, there are lots of legal aid organizations that help with this kind of thing and do eviction defense. So definitely second what Naomi said. If you get a notice of eviction, take it to an attorney.
We also have another question here. Is there a timeline for protections from evictions due to landlord's choice to do major renovations?
Oh, actually, that is a great question and a good point, because the one no fault eviction that is prohibited by the state of California right now is for intent to substantially remodel. So that's currently prohibited by the state law, and it might be prohibited by your local protections as well. It's always good to start local when you're trying to figure out what you're protected by. Look at your city first. If your city doesn't have anything, look at your county and then go to the state, because usually the local ones can be a little more protective. Not always, I shouldn't say usually even, but sometimes they are. And so yes, actually the one exception to the allowing no fault evictions in the state of California is you cannot currently evict for an intent to demolish or substantially remodel the property.
Right. And it looks like in this situation, there's also, it's a family with a child with some severe disabilities. And absolutely in that case, you could also ask for a reasonable accommodation to rescind the notice. And probably what we would do if this was a case that we got, we would say, well, this notice is invalid, currently under COVID-19 because, landlords cannot evict now due to major renovations. And also, please rescind this as an accommodation because it'll be difficult to find housing for a family with a child with disabilities during the pandemic. Puts that child at greater risk, health risk, and whatnot.
Mm-hmm.
Okay, so let's move on to the fair housing oriented part of the presentation. Okay, great. And if other questions sort of come up as I'm talking, or you have questions about what Kate presented on, feel free to put them in the chat, or we can have we can discuss them after the presentation. Okay. Bear with me 1 second. Okay. So I'm going to be focused on fair housing protections for people with disabilities during COVID-19. As Kate mentioned, all the laws that I am going to go over, pre-existed COVID-19, will exist after COVID-19. But of course, I think we all kind of recognize that COVID-19 has changed our society, and it also has kind of revealed a lot of the inequities and problems that we've long had in our society. And so there are lots of kind of issues with discrimination that are coming up in housing, in other contexts, you know, specifically during COVID-19 that I want to be able to focus on a bit. So this is just a brief review of fair housing laws. A lot of people have heard of the Fair Housing Act, which was passed in 1968 in the wake of the assassination of Dr. Martin Luther King. And the ambition of the Fair Housing Act was really to start to redress, you know, basically 400 years of race discrimination in this country, particularly focused on you know, the redlining that occurred in the 20th century when folks were spreading out over the country and buying houses, and Black people in particular were prevented from purchasing homes in many places, and therefore from, you know, acquiring the kind of familial wealth that, you know, really provides that sort of stability, right, in a country where we've had all sorts of economic ups and downs over the last many years. So the Fair Housing Act was intended to force, you know, folks selling houses, renting houses to rent to people, even if, you know, they themselves had an objection, you know, based on some of these categories. So originally, the discrimination in housing was prohibited based on race, color, religion, national origin. Sex, disability, and family status were added later. Sex, it was gender. Disability is physical or mental disability. And family status is basically a family where there's children under 18 or somebody is pregnant. Historically in this country, up until I would say the 1980s, a lot of landlords, HOAs, et cetera, were saying, oh, we don't want families here, it's too loud, that kind of stuff. And that is absolutely illegal now, with very, very limited exceptions. There's some senior housing where they're allowed to, you know, prevent children from living there, but very, very limited. And the other type of family status, the type of family status discrimination we see now is a lot of like families with kids being directed maybe to like ground floor apartments because they're worried they'll be too loud, or a sign that will say like, you know, kids can't use this part of the complex, no playing here. That stuff is illegal. And then in California, we have our own version of the Fair Housing Act. It's called the Fair Employment and Housing Act. And I'm actually just gonna switch to the next slide because it's a little bit prettier and goes over the same information. You see on the left are the federally protected categories that I mentioned before. And on the right, these are these additional categories of folks that we protect from discrimination in housing in California. So you also can't discriminate based on age, ancestry, sexual orientation, and gender identity. You know, it's interesting because there's a federal court case last year that came down that said that it was actually in the employment context, but it also applies to housing, that it's now against federal law to discriminate against people in housing or employment based on their sexual orientation or gender identity or expression. So I'm gonna have to maybe move these two items into the left category, but it's good to know that that's currently illegal at the federal level, and if folks are being discriminated against based on their sexual orientation or their gender identity, they could now, you know, file a federal lawsuit, or they could file a complaint with HUD as opposed to just within California. Let's see, genetic information. If somebody has, you know, genetic information that somehow a landlord or housing provider finds out about some disease that they might eventually get or have, you know, they can't be discriminated against in any way based on that. Marital status doesn't come up some more, but it used to be, I don't, you know, rent to couples that aren't married, stuff like that. Citizenship, immigration status, primary language. These are all protected categories in California, and folks can't be denied an apartment because, they don't speak English or they don't speak Spanish, they're not an immigrant. Landlords cannot require somebody to provide a social security number as a condition of applying for or renting a unit, because that would weed out potentially non-citizens. So that's just the type of stuff to sort of be aware of. And also, as of last year, military veteran status is protected. So folks can't be denied housing or treated any differently based on those statuses. This is something that comes up a lot, like which housing providers, lenders, who actually has to follow fair housing laws. And it's pretty much anybody that touches housing. So that includes landlords, mobile home parks, condo complexes, homeowners associations. You see a lot of cases with homeowners associations, sometimes refusing to accommodate people. Licensed care facilities, including board and care, nursing homes, unlicensed care facilities, like a lot of the sort of drug rehab type places, they also have to follow fair housing laws, make accommodations for folks. Transitional housing, homeless providers, homeless shelters, master tenants. And we see a lot of nonprofits in LA that are, and I'm sure this is also happening up north, where a nonprofit will master lease a bunch of units and then sublease them to people that may have had difficulty getting their own units due to a history of homelessness or disability. Those master tenants, those nonprofit housing providers, cannot discriminate and have to provide accommodations. And of course, the same thing applies if you're looking to buy a home. Mortgage brokers, lenders, real estate agents, and also public housing authorities have to follow fair housing laws. And what that means is that they can't refuse to rent or apply different conditions to somebody that fits in one of those categories. So you can't say, oh, well, Jewish people have to, go through a different type of background check, or, if you, have a disability, I'm going to need some type of additional paperwork. Or we've also had cases where somebody realizes in their building that it's the tenants speaking Spanish that are being denied apartment fixes, the landlord won't come to make repairs in their unit. So any type of differential treatment like that likely qualifies as illegal disability discrimination. And then of course, probably the most prominent, the most common type of discrimination that we see now is failure to provide reasonable accommodations for people that need accommodations or changes based on their disability. So in California, a lot of folks are entitled to protections of fair housing laws based on the category of disability, because we define disability so broadly in California. On the federal level, disability is denied as a substantial limitation on a major life activity. And in California, it's just a limitation on a major life activity renders you disabled for the purposes of fair housing laws. And major life activities are things that a lot of people do every day. So walking, bodily processes like breathing, working, thinking, socializing, learning. Folks with learning disabilities qualify as disabled under fair housing laws in California. So the category is very broad, and so a lot of folks are entitled to accommodations based on disability in California. Also, alcoholism, current alcoholism, past alcoholism are considered disabilities, and past illegal drug use, as long as that drug addiction is no longer active, as long as there's been a rehab program or a couple of months of sobriety minimum have passed, and that person is still being impacted by that former drug use, they might be entitled to an accommodation. But current illegal drug use is not a disability. Now, I know that a lot of folks that have, alcoholism and illegal drug use histories may have an underlying physical or mental disability that they are attempting to medicate through these means. But to the extent that folks have not been diagnosed with also, mental disability or a physical disability that would entitle them to an accommodation, they could ask for an accommodation based on, past drug use or alcoholism. An example that I like to give is we had a client who was sober, but when he was, there was a time where he was using drugs and alcohol and was actually like stealing to support his habit. And so he had a felony conviction. Now later, of course, he'd gone to jail, he'd sobered up, he was getting all this support from all these different programs, and was trying to get into housing. And this felony conviction would pop up on, for landlords, and they were refusing to rent to him. So in this case, we were able to ask for an accommodation to look at other indications that this person would be a good tenant, despite the fact that they have this old, felony conviction. His case, he had a Section 8 voucher, he had gone through rehab, he had a case manager. There was every reason to believe that he was going to be a good tenant going forward. Disability also includes a record or history of having a disability, and includes people that are perceived to be disabled, even if they may not be. And this has come up during COVID-19. For a while, we were getting reports of some landlords refusing to rent to people that worked in the healthcare field because they were worried that they might get COVID-19 or bring COVID-19. And that's perceived disability discrimination, because even if that person may not have a disability, may not even have COVID-19, they're being regarded as if they do. So that would likely be disability discrimination, based on perceived disability. And also any family member's disability can qualify a household for an accommodation. So the question of whether COVID-19 is a disability is actually like a pretty interesting one. And I think, I have to give the sort of lawyerly answer, which is like, maybe it's a disability. It very much depends on the circumstances. I think we all know, that there can be a range of responses that folks have to getting infected with COVID-19. Like some people just lose their sense of taste for a few weeks and, maybe have a cough, and then they're like, back to their baseline. Whereas some folks, are hit very severely, end up in the hospital, may have like long range kind of impairments. And when you're getting into that, that's likely that person, if they're impacted, it goes back to what we were talking about before. Like if their activities of daily living are, impacted, particularly if it's over a long period of time, but it doesn't necessarily have to be, then that person may be considered disabled based on their experience with COVID-19. And of course, there are also, as we know, a lot of health conditions that make people more vulnerable to severe COVID-19, like some severe obesity, heart conditions, diabetes, COPD, all this type of stuff can make people more vulnerable to COVID-19 and therefore might entitle them to an accommodation. Say they had agreed to move out of their unit during the pandemic, but they thought that, the pandemic was going to be over, and they didn't realize there were going to be, variants circulating, and they were going to need a booster or whatever else, and it's not quite ready yet. So they, even though maybe they had agreed to move out, they could ask for more time to move based on that vulnerability to getting COVID or severe COVID. So as we discussed, a lot of discrimination, particularly historically, has been affirmative discrimination, right? Like I refuse to rent to somebody that's Black. I refuse to rent to, families with children. I refuse to rent to people with Section 8 vouchers. That's a protected source of income now, right? Landlords cannot refuse to rent to somebody with any type of housing subsidy that covers the entire rent, including Section 8. And we still see this. We still see this type of discrimination, but the most common type of discrimination that we see now is failure to make accommodations for people with disabilities. In some circumstances, people with disabilities may actually need to be treated differently in order to have the same access to housing as everybody else. In the same way that somebody who uses a wheelchair will need a ramp or like a contiguous service to get into a building. They can't just go up the stairs like everyone else. If they want to be able to use and enjoy that housing, they're going to need a modification or a ramp to help them get in. You know, the same thing applies for people that need emotional support animals, or that need to pay their rent later because that's when their Social Security check comes. I mean, they may be able to get into the building, but they won't be able to successfully enjoy and stay in the housing unless their mental disabilities or whatever disability they have are being accommodated. Discuss that briefly. So I mentioned that accommodations have to be reasonable. Not any accommodation is required by fair housing laws. So an accommodation is a change in the rules that helps a person with a disability access housing or housing related services. And it's a change in the rules that's necessary due to the disability, provides equal access to housing, and is not what's known as an undue burden, a fundamental alteration, or a direct threat. This is basically like it's too expensive, is undue burden. And again, expense is always considered in regard to the resources of the landlord or the housing provider. So if you're dealing with a small mom and pop, they're going to be less likely to be required to pay a lot of money for some sort of accommodation than it would be if you had like a corporate landlord. But guess what? A lot of buildings right now are owned by corporate landlords. So I think the bar for undue burden and the expense is pretty high in terms of what landlords may be required to to pay to accommodate someone with disabilities now. Fundamental alteration would be if you're asking the landlord to do something that's like totally outside their business model. For example, most landlords, probably don't provide a whole lot of services. And so asking them to walk your emotional support animal, if you also have a physical disability, might be a fundamental alteration because that's not part of what they do. And direct threat is if there's the accommodation you're requesting, directly threatens, physical health, is an immediate threat to like the health and safety of tenants or employees, or substantial property damage. And also the bar for direct threat is really high. So it can't just be a person with a mental illness or a child who's really loud and not controlling what they're saying. It has to be that actually, this person is likely to injure, cause like severe bodily injury to somebody. It can't just be like an idle threat. And also that landlords who are alleging that they can't accommodate somebody because it's a direct threat also have to try to make accommodations that will minimize that direct threat, right? So let's say you have somebody, we have this occasionally where folks with mental disabilities will undergo some sort of trauma, right? And their symptoms will sort of start to kick up and they'll be really loud and, shouting at the manager or whatever else. And then they get like threatened with eviction, right? But if that person is able to make an accommodation request, say, hey, this was related to my mental illness and it was exacerbated by the trauma experience, but now, I'm like working on like shifting my medication, I'm getting into therapy, I have, I've designated somebody who's going to communicate with management for me. You have to try to accommodate that person before you evict them for direct threat. So in most cases, these exceptions to housing providers' requirement to provide accommodations do not apply. And there has to be, the most important thing in requesting the accommodation is there has to be a connection between the accommodation and the disability. So for example, if somebody let's say there's a tenant that has anxiety and they're triggered by being around a lot of people, or there's a family with a child who's on the spectrum that is, doesn't do well with a lot of ambient noise. And there's a main entrance that everybody in this large, complex has to use. And then there's a side door that's only used by like maintenance folks or whatever. It's not typically permitted for tenants to use that door. But if that side door is in a quieter area and will let that person with the disability that's exacerbated by noise and chaos enter their apartment and not feel threatened, they can absolutely ask, for example, for an accommodation to use a different a side door if it's, you have that connection with a disability. Here's some examples of accommodations that folks may ask for during COVID-19. Perhaps you need a live-in aid due to any disability, including, disability that results from COVID-19 infection. That could be an accommodation you could ask for, even if there's a limit on the number of folks you're allowed to have in your unit based on your lease. Of course, tenants self-isolating due to health conditions that make them vulnerable to COVID or at COVID can request virtual inspections, can request postponing non-urgent inspections. Folks living, that are vulnerable to severe COVID-19 due to like age and, disability, who are living on the streets or in a homeless shelter, congregate shelter, could ask to be relocated to a facility with a private room. This slide goes over a little bit of like what the accommodation process is. I want to just be mindful of time, but suffice it to say that anybody in the household can request the accommodation. You can request it on behalf of yourself. You could request it on behalf of a minor child. You could request it on behalf of a person with a disability who's an adult, but who asks you to request this accommodation for them. And you just want to make sure to put the request in writing if at all possible, so you have proof that you've made this accommodation request. You want to title it reasonable accommodation request. It's not necessary to use those words to get the accommodation, but it puts the housing provider on notice that you're invoking all these really powerful laws, and it's likely that they will pay more attention. And you just have to state that you have a disability and then explain what accommodation you're asking for, and then explain that nexus, that connection between the accommodation and your disability. So for example, if you're asking to, let's say you're in a situation where you are homeschooling your child and there's a lot of more noise that happens during the day because you have a child at home, and that child may have disabilities and maybe expressing themselves in a way that some of the neighbors can hear. You could absolutely, and you get a notice from that, right? From the landlord saying, you have to be quiet, or I'm gonna evict you, or whatever else. You can absolutely ask for an accommodation, like explain the relationship with COVID, that's why we're home now more. And also my child has a disability. So sometimes they may, express things like in a slightly different way than other people might express them. Sometimes the volume is like fungible, whatever else. If you can connect that to the disability and ask them to let them suggest request that you be allowed to continue to stay at home with your child and homeschool them in the way that they need without running afoul of any sort of noise requirements or tenancy requirements that there may be. And folks can ask request multiple accommodations. We have a lot of folks that have an emotional support animal or a service animal, and they have accommodation for that. They also pay their rent, later in the month, because that's when they get their disability benefits. And maybe they actually need to pay their rent in a different way than everybody else because their disabilities prevent them from using the online system the landlord wants them to use. So you can have all the accommodations that you really need in order to, enjoy your tenancy, as long as they're not, again, rising to this level of being too expensive for the landlord or changing their business. As Kate mentioned, you can ask for an accommodation at any time. So that's during application, tenancy, or eviction. And as I mentioned, sometimes if somebody has a criminal like a criminal charge on their background, or maybe even just an eviction, and if it's related to their disability somehow, they can request an accommodation to be admitted to a unit as an applicant, as a tenant, despite that, despite what's on their tenancy record. I noticed that the evaluation just went up. We're trying to stuff a lot of information into a short space. So if folks would mind just addressing these questions that we put up here, it just helps us understand what folks are learning from the presentation, and it helps us sort of make improvements in the future. So we'd really appreciate it if you would take a couple of minutes to fill out this anonymous survey. And then I think what I will do is, the last thing I want to point out is that in a lot of cases, when you make an accommodation request, a landlord may ask for verification, right? They may say, well, you're telling me that you need this, right? You're in a wheelchair, you're on the second floor, you're telling me you need to be relocated to a downstairs unit, but I need proof. And in that case, it's not appropriate because the disability is obvious, right? They know you're in a wheelchair, so you don't have to explain the nexus between the accommodation you're requesting and your disability, because it's obvious. So if it's obvious or known to the landlord, they shouldn't be asking for that information. They shouldn't be asking for medical records or all sorts of detailed stuff. They're not permitted to have that information by law. But it can be helpful in certain circumstances to have a verification of disability and need for accommodation letter. If you could get it from a doctor, a social service provider, a therapist, a caseworker, it does not have to come from an MD. It could be any third party that's in a position to know about the person's disability, including a family member. So that's a good thing to know. And actually including the person with a disability too, right? So if you're asking for, to pay your rent later because that's when your SSDI check comes, all you need to provide them is, proof of when the check comes, and that's it, right? So in most cases, the verification can come from the person with the disability or their family or, a support person that they're working with. And the last thing I want to mention is that folks can file, let's see, I already went over that. I went over this stuff. Oh, reasonable modifications we didn't really get to, but that's a physical change to the property. So somebody needs a ramp, somebody needs a bar in the shower. Landlords are required to permit folks to put those in, but unless there's a federal subsidy on the unit, on the building, the tenant might have to pay for that, although there are various ways to get help to pay for those modifications. So that's another good reason to reach out to legal aid if you're having difficulty with that, to negotiate that with the landlord and also help connect you to some of those resources that could help pay for the modification if the landlord doesn't have to pay for it. And then these are the places where folks can file fair housing complaints if they're experiencing discrimination, denial of reasonable accommodation. And of course, last thing I'll say is, Kate mentioned that we're primarily in LA County, but we do provide advice and counsel to folks on the phone, even outside LA County. If you call our phone number. I know it's already after 1.
It's okay. It's okay, Naomi. Thank you. I know this has been such great information. So there's still some questions, and I have a feeling that can we have another 3-4 minutes just to get to the questions in the chat? And
yeah,
I know, I mean this, and I just want to let everybody know this is being recorded, and this Naomi and Kate's slides will be on our Family Voices website. We'll send that to you all in an email, or we can put it up here in the chat. But so the recording and the slides will be available. So the chat, I'm sorry, I closed out of it.
Oh, I've got it if you want.
Oh, you've got it. Okay, wonderful. Thank you, Kate.
So there are only 2 questions, I think. So the first is, does a live-in aid need to be added to the lease? Which I think depends on where you are, like so many things.
Right. Yeah, I think it depends on the situation. If the person is actually living in the unit, it's likely a good idea to put them on the lease. But I do know that if you're dealing with a housing authority, a live-in aid will not be on the housing voucher, right? So that in that case, it would make sense though to have them on the lease itself, just to provide, having somebody on a lease, it protects that person, right? Because then it's clear that you have those tenancy protections if you ever try to get evicted, or if you're ever at risk of eviction. It sort of protects that person.
And I know there are some local laws that protect you from being evicted for an unauthorized additional occupant if that person is like a live-in aid. But again, that's super specific to, you know, the
Yeah. If somebody
and also still would be a good idea to ask.
if somebody needs a live-in aid for some disability related reason, like absolutely, I can't imagine the situation in which the landlord wouldn't be required to provide that as an accommodation. I was just thinking, like, we get these cases where folks have been living as a live-in aid with like an elderly parent, and then the parent passes away, and then the kid is in the house, and now they don't have the subsidy from the housing authority, and they're not on the lease. So it is something to think about, sort of, you know, making sure that the aid is protected as well. You know, if they would ever potentially want to stay there without the person that they are assisting.
Yes. Oh, sorry, Pip, do you want to?
No, you're seeing the questions, Kate, so I'll let you take it. Thank you.
Okay. So Yoselin has another good question. So she says, I'm a single mom and my child is on the spectrum, nonstop moving, and it's very difficult to take him to the park or street for a walk. And she said her voucher doesn't allow enough to rent a home in her town where her family and the other people who help are. And so she's wondering if she's able to ask for an accommodation for more room or to increase the voucher to allow her to rent in her town where she has support.
I mean, that's absolutely an accommodation request that we have made and that we recommend that people make. If you need, if the voucher amount isn't enough to rent a unit that meets your disability related needs, right? So that could be being close to family support, you know, medical providers, like what, you know, if you need maybe a bigger space because you have medical equipment, you can absolutely ask for an increase in the payment standard. I think typically, this may be getting into the weeds a little bit, but you know, if up to 120% of what the housing authority considers the fair market rent is usually something they can grant themselves. If it's over that, they have to go to HUD and, you know, ask for a waiver. But this is a really good thing, I would say, to you can let us, you know, you could even contact us and we can look up for you, you know, if you wanted us to, like what the you know, it depends on like how much more you need, right, in that voucher. So we can help you look up sort of how easy that's going to be and who to direct your reasonable accommodation request to. Is it just the local public housing authority? Do you have to go to HUD? Because it's a higher amount. But this is a very important reasonable accommodation request that really benefits a lot of folks with disabilities.
Yeah, and you can, I'm sure, contact legal services in Northern California.
Exactly. If you're in NorCal.
And I mean, welcome, not to push you away from us. You were welcome to come. I just want to throw that out there. But also, if you're looking to, so if the issue is that you have it through your local, through a city and you're trying to go to another city, sometimes there are certain restrictions on where you can move your voucher to, or they call it porting. And that's something else you can ask for a reasonable accommodation about as well, as to allow you to move that voucher.
Right, to a whole different jurisdiction, as opposed to getting more money to pay for housing where you are. Both are potential reasonable accommodation requests.
Yeah,
I mean, that's the great thing about reasonable accommodation law, is it just provides so much flexibility that people with disabilities really need now, particularly in this, you know, this really tight housing market. So it's a really good tool, you know, to help get housed and get your needs met.
And it seems to me that this is a great message to actually go and talk to legislators about. Some family advocacy here, because Jocelyn, I'm sorry, I'm mispronouncing your name, but I mean, I think that there are probably hundreds and hundreds of families just the same in your same position, that we could really rally behind and help, you know, get this to be something that the legislator knows.
Right. Yeah, no, I know in Santa Monica where I am, you know, because rents are so high, like the housing authority the city actually applied to have like an extra high payment standard for the city so that folks could actually lease up here. So that's definitely the kind of thing you could advocate on with your local jurisdiction as well, just raising the payment standard in general to make it more useful.
And on that note, Jennifer said that her city is offering a housing element town hall, and she's asking if there's a resource we can recommend to bring up important current issues that for people with disabilities that the housing element should be addressing.
That's
a tough and big question.
Yeah, I mean, I know, one of the biggest issues that we face, so there's a shortage of affordable housing in general, right? But a lot of the affordable housing that we have is not accessible to people with a variety of disabilities. In particular, the rent-controlled housing, because the way the laws are written, like housing built after 95 can't be rent controlled. And most of the accessible housing has been built in the last 20, 25 years. So we really need to work on building accessible, affordable, permanently deed restricted housing. I'll see what resources I can find to send out to Jennifer Kim, because that's a really good question. And I'm so glad to hear that folks are getting involved in the housing element process and advocating, because it's just so important this year more than ever, right?
Yeah, as all the commercials keep saying, now more than ever.
Now more than ever, right?
Yeah, great question.
Making a note of that.
Oh, and she just dropped her email in the chat as well.
Oh, great. Thank you so much.
And Denise said it's too much to expect due process in the pandemic. And the San Francisco court is not functioning at a high capacity by the sound of things. And she said that her landlord has been committing numerous violations, criminal behaviors, and is asking for her options. So again, I mean, can't say it enough, get an attorney involved. I'm sure, Pip, you might have more resources for organizations in San Francisco that might be able to help.
Yeah, we do. And then what I'm going to do is pull those all together and email all the attendees with those resources that I know throughout the state and the San Francisco Bay Area and Sacramento. I mean, Kate and Naomi, I mean, you've certainly given us so many today, but I'll see what I can, find out more. And it's time to rally.
Definitely. And if you have, San Francisco, I'm sure has a tenants union.
They do.
That is also something, and I know that a lot of times they have like fees to be part of the tenants union, but a lot of tenants unions are waiving those fees right now or reducing them. So I would look into joining your tenants union, because sometimes they mobilize in this really effective way. And also, if your landlord's doing it to you, chances are they're doing it to your neighbors. And so you could even potentially, I mean, you don't have to be the one, but the tenants union could mobilize, other people in your building as well, to help stop this. I don't know how the city attorney is in San Francisco, but technically I think they're the ones that are supposed to enforce a lot of this stuff. So it's also potential that you could go there. If you feel like you're being discriminated against on the basis of some class that's protected, you can also make a complaint with the Department of Fair Employment and Housing, which that link is on that last slide that Naomi was showing.
Right, and we'll be sending out the slide. We have another question about somebody receiving a 60-day eviction notice and being basically harassed by their landlord. Now, typically 60-day eviction notices are no fault evictions, right? They're just, we want to get you out, and they don't give a reason, and that's not permissible now.
Well, it is in California.
What?
Oh, no fault. Oh, no, you mean no reason.
Yeah, no reason, right? I mean, typically those 60-day notices are no reason evictions, right? We just like, your lease ends in 2 months. So I definitely would get that eviction notice to legal aid, to an attorney to look at that and see if that's valid. Also, it sounds like this person is experiencing harassment, which is, there have been a lot of harassment laws. Look, the CDC order has like significant, which applies to everybody, right? Has significant penalties for harassment. There's also a lot of local jurisdictions have raised the penalties for landlord harassment. So calling, urging, banging on your door, whatever else. So absolutely there are laws that protect you from this type of behavior. So I would get to an attorney so they can help you kind of investigate what your what your next steps might be.
Yeah, I think that's the big message that we have is don't be afraid to go to an attorney. There is free legal help available. There are also, as I mentioned before, self-help clinics in a lot of courts. You know, really like feel empowered to take advantage of those resources. And tenants unions, not even in San Francisco, anywhere you are, if you have a tenants union, that can be a really, also just a really empowering experience to be a part of a tenants union. And so I strongly encourage everyone to join their local tenants union, make them stronger, and get that sense of empowerment because
Right, exactly. I think a lot of the time what happens is folks get these eviction notices and they get scared because, they're busy leading their lives. They're not following
and
eviction.
it's scary.
When you get a notice that says to leave, you might just leave. But actually, in most cases, that's not a great idea. and you might want to fight back, particularly in this climate.
And it's also a form of intimidation upon people that are totally underserved anyway. So it's one more thing, and it's very scary. But it is 1:15, and I can't thank you enough, Kate and Naomi, for your wonderful presentation and for hanging in here to answer more questions. But so everybody's still on. We're going to be Family Voices will send out emails regarding different resources for you all. This, and also the PowerPoint and the recording will be posted on our website. And thank you for all of you who responded to the poll, the survey, because it's really important. So, here's one more. I'm going to.
That's me. I'm just making another point.
Thank you all, and goodbye, Kate and Naomi. Again, we really appreciate your time.
Yes,
thank you so much.
Okay, bye-bye.
Bye.
Bye.
Bye.